Good afternoon, everyone. We're going to give it about 30 seconds or so before we get started today. Just letting everybody trickle into the room. Awesome. Well, I see a number of us have joined in. So in the interest of time, we're going to get started. So thank you, everybody, for joining our conversation today around public charge, its current state, and what you need to know. Today's presentation, we have two amazing attorneys from the Immigrant Legal Resource Center, Aaron and Ariel. They'll be guiding us through our conversation today. Before we get started, I do want to go over some general housekeeping items, and then we'll start the conversation. So today's webinar is going to be recorded. I will share a copy of today's presentation along with the PowerPoint and every single link that we are sharing with you today. There's a number of very valuable resources that we're going to share with all of you. So I want to make sure that you have those. So it'll be shared to the email that you used to register for today's conversation. Contact information for our two panelists will also be available at the end. And as I mentioned, we'll utilize the chat feature to share links and resources throughout the conversation today. We also have some closed captioning available. So if you hover either at the bottom or at the top of your screen, depending on how you have it set up, you can enable the captions. And then finally, if you'd like to ask questions, we ask that you use the Q&A tab to ask our presenters today, and we will get to hopefully as many questions as we can towards the end of our presentation today. With that, I will pass it over to Erin to do a quick introduction of herself before we start our conversation.
Great, thanks so much. Hi, everyone. My name is Erin Quinn. I'm a senior staff attorney at the Immigrant Legal Resource Center, and I'm excited to be here with you today to talk to you a little bit more about public charge and how it might be impacting you, your families, and communities. I'm here with Ariel, if you want to just say hello real quick.
Hi, everyone. Ariel Brown, staff attorney at ILRC.
Ariel. So we're both folks that work in ILRC's, the Immigrant Legal Resource Center's public charge team, and we hope we can answer the questions you have today. So let's go ahead and just jump right in with what is public charge. We plan to start off by just talking to you a little bit about what the concept is, a little bit about the law, and then go into some specific scenarios and updates. So let's go ahead and move forward, Alonso. All right, so when we think about public charge, one thing to just flag right off the bat is that the term has been thrown around so much in the media and through the politics and policies we've seen in the last 5 years that the term itself has become pretty loaded, and I think it instills a lot of fear in communities, particularly because it sounds so negative and so heavy, and yet we don't really know what it means. So first, let's just put it in its place. The term public charge actually refers to a specific piece of immigration law. And generally speaking, the way it functions in immigration is that it's a test or an assessment for some immigration applications. And it's about determining whether an applicant is likely to depend on public benefits in the future. So let's break this down even more on the next slide. So generally speaking, public charge is this idea of we're going to assess whether somebody is going to be dependent on the government in the future, and we're using that test as a way to decide whether they're eligible or not eligible for a particular immigration benefit. But it's really, really more specific than that. Public charge lives in just one little piece of our immigration law. So it doesn't impact all applicants, and it doesn't impact all types of immigration status. The law itself is about a couple sentences long in our statutes passed by Congress talking about this idea that somebody who is likely to become a public charge is not admissible to the United States. So that type of bar only applies in certain cases. And specifically, we now have guidance and some rules around what that means and what an officer or a decision maker on an immigration benefit would look at to determine public charge. So right now, our definition of public charge is the idea about considering whether someone will likely become what we say primarily dependent on cash aid or long-term institutionalized care. So a few things should jump out at you right away. Is first, we're looking forward. We're talking about the future. We're not talking about whether somebody needed a benefit in the past, but what the future will look like. Second, we're talking about somebody becoming primarily dependent on cash aid. So that means more than half of their subsistence or financial well-being is coming from cash aid or long-term institutionalized care. So we have a couple concepts there. One, that it's primary dependence, not just supplemental. And second, that it's cash aid or long-term institutionalized care. So no other public program or benefit is an issue when you're assessing whether somebody might be a public charge. We'll break this down even further as we talk for the next hour, but the idea is then, as you can see right away, that this law isn't going to impact all immigrants or all immigrant families. And also, it has nothing to do with who might be eligible for a particular public benefit or a program. So our states, our localities, our schools set up many different benefits and programs with their own criteria of who is eligible. And none of that is impacted by public charge law. Public charge law only comes into play if a person comes forward to apply for certain type of immigration benefits, and then it only will implicate a couple types of benefits that a person might receive in their future. Let's look at the next slide. I already mentioned that access to benefits really isn't impacted by our public charge laws. Public charge is really about who may be eligible for very specific immigration benefits. And that's really important for all of us here in California, because California and various counties and localities in California offer more benefits and programs to immigrants and their families than many other states. So a good example of this right off is the idea of Medi-Cal offering healthcare coverage to families in California. And under our current Medi-Cal rules, we have Medi-Cal for anyone that is a resident with the right income eligibility through age 25, as well as those that are age 50 and over. And that's regardless of immigration status. So those eligibilities aren't impacted at all by public charge. And just a spoiler alert, as you might have noticed by cash aid, also any healthcare programs like Medi-Cal don't cause a problem on the immigration side. So right up front, things like Medi-Cal and healthcare, not only is our eligibility still there, but also it doesn't impact anyone on their immigration pathway. People should be getting the health care they need. All Medi-Cal is safe to use and won't impact somebody on their immigration pathway, regardless of what that pathway is. Let's go ahead and talk a little bit more about types of immigrants. So on the next slide, we're talking about some of the different immigration statuses. A really important takeaway is, as many of you already know, immigrants might have various ways that they are here, and family members might not all be in the same status. So some people might have refugee status or asylee status. There are youth that have qualified through special immigrant juvenile status. We have people that are here that have obtained U visas or T visas as victims of crimes. There are green card holders or permanent residents, as well as citizens in our immigrant families. And all of these different statuses might come into immigration law in different ways. When we talk about public charge, the statuses on your screen now have no public charge test. So public charge isn't even one of the laws that applies. A person can be a refugee or asylee or get that status, U visa status, T visa status. They can be in those statuses and not worry about public charge. Permanent residents, once they've become a permanent resident, are no longer subject to this public charge law that we're discussing today, and citizens are uniformly not subject to public charge. So all the folks on your screen now should be using any program for which they qualify that will help them or their families, and not be concerned about what the public charge law may say because it doesn't apply to them. Let's go on to the next slide. And then people get their statuses through many different pathways and processes. So folks will apply to get an immigration status, usually by turning in an application to immigration. That can be a direct application for getting a green card, or it can be one of those other statuses we just showed on the screen. Importantly, the public charge test only applies in some types of applications. And the most common one, the main space that public charge shows up, is in the pathway of somebody getting their green card through a family member petition. So other than that process, generally speaking, public charge is not going to be one of the main issues or eligibility criteria for getting an immigration benefit. So looking at the example on the screen here about Yali might be helpful. If Yali marries a US citizen, and Yali's spouse files a petition for Yali saying, hey, this is my spouse and I want to petition her. Based on that relationship and the petition, that family member petition would be approved, and then Yali would be eligible to apply for a green card or get permanent residence. And in that pathway, this is the most typical pathway where public charge does apply. Yali will need to show that she would not be likely to become a public charge in the future, and this is when that test applies. So notably, if we look at the next slide, public charge is really only going to come up in two situations. First, somebody who's coming to the border and looking to enter the United States is subject to what we call admissibility rules, and public charge is one of them. And so practically speaking, the next is either coming forward to say, hey, I have a visa, let me in, or the person is getting interviewed here in the United States for their green card. It's called an adjustment of status to get a green card through their family member or through an employer. And in that situation, the public charge test applies, just like what we saw with Yali in the above example. That means all the other ways that you can think that people might be getting an immigration status or benefit have no public charge test. So let's look at the next slide. So as you can see, coming up are all the other various pathways to getting an immigration status here in the United States. And the ones on your screen now have no public charge test. So not only are we only worried about some benefits, if we're worried about public charge at all, cash aid or institutionalized care, but most immigration benefits don't even have a public charge test, so we're not worrying about it at all. If somebody is applying for DACA or temporary protected status or a U visa or asylum, or getting a green card, but getting a green card because they're an asylee or because they have a U visa, none of those applications have a public charge test. Renewing a green card, removing a condition after getting a 2-year green card, applying for citizenship. All of those processes, all of those applications are applications with no public charge test, so we wouldn't even be worrying about public charge. Let's go ahead and really look at some examples here, because these are questions we hear so often that we thought it'd be worth shouting them out. The first example on the next slide is, well, okay, so when a person is renewing their green card, are they subject to public charge? What do you all think? If you're looking at the list, you already know. No public charge test. And what about if someone's applying to naturalize? So they're a green card holder, they're using benefits because they qualify as a green card holder. Again, the answer is no. There is no rules about using any benefit programs and applying for citizenship. We hear a lot that people are worried about using various programs because they think it might hurt their application for naturalization. And that is just simply not the case. It is not one of the factors to naturalize or to gain citizenship. In fact, using some public benefits is a way to get a fee waiver during that process and save lots of money. So it's not a bad thing to be on various benefits that, that you qualify for if you're a green card holder. So that might be leaving some of you to consider this next question, which on the next slide we're looking at is, do green card holders, those that are permanent residents or already have their green card, do they ever need to worry about public charge? And the answer is basically no. So a green card holder here in the United States is generally not going to be worrying about public charge. Green card holders often qualify for various benefits and programs, and they should be using them if it's a program that they qualify for and would be useful to them. The only way public charge can come up for someone who already has a green card is generally with travel, staying outside the United States for over 180 days in one trip, committing certain crimes. Those are reasons why somebody might become subject to a public charge test or assessment again. And that might be like a permanent resident if for some other reason is facing deportation proceedings. Usually that comes up with criminal records. If they were looking to reapply for a green card for any reason, they might be worrying about proving public charge. But again, that test would still be limited to likely to become primarily dependent on cash aid or institutionalization. So let's look at a couple examples. I'd like to start with the next slide here with Maya. So Maya has a green card and she is ready to naturalize, and she's worried about public charge and is worried about whether it applies to her. A typical example we might hear is somebody like Maya might say, well, I'm using Medi-Cal, is that a problem? Or I have gotten some other help during COVID. I got a stipend or I got some COVID care. Is that a problem? The government gave me a stipend. Can I use it? And the answer would be here is that she absolutely, we don't even have to do a test or analysis because Maya, as a green card holder and applying for naturalization, she does not have to worry about public charge. Let's look at the next example. So Jesus has DACA, and other than having DACA, he has no other immediate way to get a green card. He has no other immigration applications in the mix right now. What do you think? Jesus, in this case, doesn't need to worry about using any particular benefits or about the immigration public charge law because we already learned that applying for DACA, there's no public charge test. And so renewing his DACA wouldn't cause any public charge concern. And since he's not about to apply for anything else at this time, Jesus should use any benefits that he needs and wouldn't be worried about public charge. I would also suggest that the types of benefits Jesus would qualify for wouldn't cause a public charge problem, even if he was doing something, because Jesus might qualify for things like Medi-Cal or school programs, and none of these would be a public charge problem, even if he had an application pending that required him to show he wasn't a public charge. How about Chris? Let's say Chris is engaged to a US citizen who will be petitioning for them. Chris will need to consider public charge as part of their application for a green card, because here notice that this is a petition for a family member. So Chris is looking to marry a US citizen. And so chances are that spouse will be looking to file a petition for Chris, and then Chris would go forward with a green card application. That is precisely the kind of application where we're worried about public charge. But again, that test is based on a lot of different factors. And Ariel's going to tell us a little bit more about what would be in consideration, even if there was a public charge test. So let's turn to some other pieces of this and talk about what the current status of public charge is and some of the other factors.
Okay, thanks, Erin. And then, so we had a few questions about the examples, if we want to just take a minute or two right now. So one question was the example with Maya, who, had her green card, was applying to naturalize. Someone asked, what if she had got her green card through a family petition?
That's a great question. So in that case, the only time she would have been worried about public charge is at that minute where she applied for the green card. The officer deciding her green card would consider public charge. And probably it means that at that time when they considered public charge, there was no concern. She was able to make her showing. And so once she gets her green card, she's now done. And she doesn't have to worry about it again. And it doesn't matter how she got her green card. She's now a permanent resident, and she can move through the world as a permanent resident and using benefits that permanent residents qualify for.
Okay. And then another question was about someone who is currently applying for asylum.
Great question. No public charge test. No worries.
And then, well, so someone has raised a question that, well, I guess we haven't really addressed quite yet, about their understanding that in the first 5 years of someone becoming a permanent resident, they aren't supposed to use public benefits. Do you want to address that really quickly, Erin?
Yeah, that's a great one. So at the national level with certain benefits, there's a 5-year period where people are, a couple things happen. Mostly it's that somebody's not eligible for benefits. So a lot of the federal programs say that a permanent resident within the first 5 years is exempt. They just don't qualify for most of these benefits, cash aid, and even Medicaid. California has already made an exception, and through state funds allows permanent residents in those first 5 years to use lots of benefits, including Medicaid. And so that really is an eligibility question, not one about public charge. And in California, we have different rules. So we don't have to worry about that 5-year rule here. And that would be something that if you were talking to county or signing up for healthcare, they would be able to assess eligibility. But by and large in California, we've done away with that 5-year wait period.
Right, and as Erin has been saying, right, public charge doesn't change people's eligibility for benefits. It just has to do with any possible immigration consequences if they turn in an immigration application. So I see another question here about someone who has DACA, is considering applying for benefits like CalFresh. Will public charge apply? So remember, public charge doesn't have anything to do with their application for CalFresh or other public benefits. And someone who has DACA isn't subject to a public charge test. If down the road they're subject to a public charge test, CalFresh still wouldn't be considered because it's one of those benefits that doesn't count. And in this next section, I'll go through some more specific named programs. You know, Aaron said there's really only two types of programs, the cash assistance for income maintenance and then the long-term institutionalized care. And so I'll talk a little bit about what kinds of programs fall under those two sort of umbrella categories.
Great. And just one more question I see related to this first part. Yeah, so we'll dig in a little bit more about programs. We'll dig in a little bit more about what they do look like at when they're looking at public charge and what matters. But I see another question about non-immigrant visas. So folks that might be here on a visa to study, F1 or J1 visas. Technically, public charge does apply in those contexts. When we were talking about somebody coming to the border and asking for entry on a visa, that would apply here, right? A non-immigrant visa for F1 or J1, at the time they get their visa and are entering, technically are showing, they are making a showing that they will not be a public charge. And some of you might be able to think through like, oh yeah, that paperwork I had to turn in. I had to turn in a letter of financial support and I had to prove I could pay for school. All of that kind of relates to the public charge assessment. However, once people are in the United States on that status, it really comes down to, are they going to need to renew? Are they going to come and go? Are they going to trigger a time where public charge will be reassessed? And remember that public charge is going to be limited to the types of programs that are cash aid or institutionalized care. So a student in an F1, if a school has various programs on offer that are not cash aid or long-term care, or there's healthcare needs, those shouldn't be triggering any public charge concern, even in those categories.
Okay, so, you know, now that we've sort of located the public charge test within immigration law, you know, covering, you know, when it applies, which, you know, immigrants or applications are subject to public charge, I'm going to provide sort of an update on the current status of public charge. As many of you know, over the last few years, public charge has been in the news. It's been circulating in the community as a topic of concern, and it can be kind of hard to keep track of what's happening. So we'll go on to the next slide. So first off, the law doesn't define public charge. It simply says that being a public charge, among, you know, many other issues like committing certain crimes, lying on an immigration application, etc., can disqualify you from some forms of immigration relief. And so the definition that we have on what it actually means to be a public charge comes from policy guidance, which also means that it's easier to change as opposed to something that's in the books as a law. And so that's what we sort of saw during the Trump administration. They proposed a more strict definition of public charge that's no longer in effect. So the current definition of public charge is someone who is likely to become primarily dependent on the government for subsistence, and that's as shown by reliance on just two types of programs: cash assistance for income maintenance, like we've been talking about, and then long-term institutionalized care paid for by the government. So examples of cash aid for income maintenance. So it's not just cash aid, it's cash aid that someone conceivably could be trying to live off of, right? For actual income maintenance or subsistence. Includes programs like SSI, TANF, the Temporary Assistance for Needy Families, CalWorks, and then programs that are called like general assistance. So those are the main ones. And then when we talk about long-term institutionalization paid for by the government, we're really talking about like someone who's living in a nursing home or potentially in a mental health institution for like a long-term setup that's paid for by Medicaid, which is what we call Medi-Cal here in California. So if we could go to the next slide. There are many public benefits programs that don't count. So this is a non-exhaustive list. So there are more, but these are some of the main ones that we really want to highlight because people wonder about a lot of these programs. And I already saw in the chat questions about like women, infants, and children or WIC benefits. So you'll see WIC is on here as a program that doesn't count. We already talked a little bit about CalFresh, right, which is California's food stamps program. SNAP is the federal version. So that also is a program that doesn't count. We have on here, Children's Health Insurance Program, all other health insurance programs like Medi-Cal, vaccinations, all COVID vaccinations and treatment, school-based programs like nutrition services like free and reduced school meals, public education, Head Start, any earned benefits, so things like unemployment, Social Security, retirement, workers' compensation, veterans benefits is another one that we don't have listed, but that also doesn't count. Housing, like Section 8 rental assistance or federal public housing. What else is on here? Tax credits. I think we mentioned in the sort of pandemic context, right? Like the stimulus checks, those don't count. And then we have sort of this sort of catch-all at the end, right? Any other federal, state, or local benefits besides cash aid or long-term institutionalization. So we can look at this with an example if we go on to the next slide. So we have Laura, who's undocumented, and her children are US citizens, and they qualify for public benefits. But Laura is worried because she's undocumented that her children shouldn't sign up. And this fear is probably grounded in public charge, right? So Laura's children should use those benefits because their use is not going to count against her. And also, we don't even know if Laura is going to be subject to a public charge test. But if in the future she, submits one of those immigration applications, like applying for a green card through a family petition, where she would be subject to public charge, they still wouldn't look at her children's use. And, so bottom line is that Laura should access the public benefits programs that she and her children need and qualify for without worrying about public charge, since her children's use won't affect her. And we also just don't even know she'll be subject to public charge. So then this next example, which we recognize is probably a common one for this audience, is Daniel, who's a US citizen, and he's receiving financial aid. His parents are undocumented, so Daniel's worried that his use of financial aid will affect his parents in a public charge determination. So Erin, if you want to take us through this, does Daniel need to worry about public charge here? And then also, what if he were undocumented as well?
Yeah, it's a great question. So generally speaking, any aid related to education is not going to trigger public charge concerns. Under our current guidance, Ariel's going to talk a little bit about what's happening in the policy space in a minute. But under our current guidance, there is specifically listed that educational aid and programs do not count in the public charge assessment. And we have a new rule coming out where it's not specifically named in the same way, but a few things about most financial aid. So first, mostly financial aid for school isn't for income maintenance. It's not for subsistence. It's usually tuition assistance or book assistance. And some of it is loans, not grants. So for sure, all of that wouldn't count. Right now, as I said, our current policy specifically exempts these from consideration, and we're waiting to hear what kind of guidance the government will issue to make this clear if a new rule takes effect. But for sure, that's how we have it right now. In fact, even under the bad Trump days where we had really tough rules, the student aid was specifically exempted. So we feel pretty confident that this will continue to be the case. And there's two pieces that I heard Ariel asking about, which is like, what about Daniel? And also, what about Daniel's parents? So one thing that's true about this example and the last one is a family member's use of any benefit, even if it counted for public charge, will never impact another family member's immigration pathway. So that we just don't have to worry about. And then the second part here was, well, in one case, Daniel was a US citizen, and then would it change if he was undocumented? Well, if he was undocumented, it might mean that in the future someday, Daniel would have a pathway to getting a green card. So maybe someday in Daniel's future is an application with a public charge test, but that is really speculative. So one thing we want to focus on is public charge is about likely to become in the future and primary dependence, not just little bits of support or help. So all of those temporary situations where somebody might get some benefit or some support, first, if it's not cash aid, it doesn't count at all. And even if it is cash aid, what the officer is going to look at is the totality of the circumstances and what the person's future looks like, which could be very different than that moment in time where they needed support.
And then Erin, so you might have already sort of addressed this, but what about differences between sort of like federal financial aid and state financial aid? As we've talked about, right, how the state sometimes gives immigrants more assistance than we get at a national level, right?
Right. So the federal financial aid probably wouldn't even be available to Daniel if Daniel were undocumented because of the strict restrictions on federal. But in California, there might be more available to Daniel, even though there is more aid available to Daniel, maybe from a locality or a private source or a state. It likely would not count at all for public charge because it wouldn't fit that definition of cash aid. And we expect that it specifically, no matter what, would fit an exemption for educational aid. And so for both of those reasons, Daniel would be okay and should get the help that they need with education funds.
Okay, and then I guess if we want to move on to the next slide here. So, you know, in terms of what, you know, Erin's also talking about, like, even if they were to consider financial aid, so supposing Daniel were not a US citizen, later on is subject to a public charge test with some application that he's filing, and his past receipt, or maybe current if he still is currently receiving financial aid, even if that were somehow considered, if it were deemed, you know, cash aid, that might count, is to sort of keep this in perspective that the public charge test is about primary dependence. And, you know, as we've been talking about, there's lots of supplemental local programs that are meant to fill gaps in federal aid for undocumented individuals that don't amount to primary dependence. And then also immigration officers are required to look at sort of the full picture in a person's life as part of this public charge assessment. I saw in the Q&A, someone sort of asked, like, how does someone prove they're not a public charge? And so they don't necessarily have to affirmatively prove anything, but when an immigration officer is reviewing their application, they are going to be looking at whether or not they had to disclose that they received public benefits that count. And most of the time, people don't qualify to receive public benefits that count if they are undocumented. Like how we were saying, if Daniel were undocumented, he wouldn't qualify, you know, for the types of federal programs that the public charge test would consider. But supposing that they did, immigration officers would look at that. They'd also look at everything else about his situation. Is he now working? Is he, you know, married? You know, other things like that to make an assessment. And so, you know, sort of current or past use is just sort of one piece of this whole picture that they're looking at. And then another really important thing to think about is there's this I-864 affidavit of financial support that's actually required in these green card cases where someone is applying for a green card through a family member. And that's where the person who is petitioning for them and potentially someone else is promising to help financially support the person who is applying for a green card in the future if they need help. So they're saying, like, the government doesn't have to worry because they have someone who has promised to help support them if they need it. And so this is a required application, required form as part of the overall application. And it's usually treated as strong evidence that a person is not likely to be public charge. And so that affidavit of financial support is one of the main ways that a person can prove they're not going to be a public charge, and they have to submit it in their case. And so then if we want to go on to the next slide, I'm just going to talk briefly about, there's a new rule that the Biden administration announced on public charge that is set to go into effect on December 23rd. And it's really not a dramatic change, which is why we're not really spending too much time talking about it. It's basically stabilizing and strengthening the current policies that we were already talking about in terms of the definition of public charge, that they don't look at family member use of benefits, that tons of programs are actually safe to use and aren't considered as part of the public charge assessment, that they have to look at a person's entire picture when they are trying to make a projection about whether or not they're going to be a public charge in the future. And so all of that is set out in this new rule that is proposed by that was announced by the Biden administration. And it's really not going to change much about how public charge has been evaluated for the last over 20 years, minus that brief departure from longstanding practice during the Trump administration, which is no longer in effect. So then if we want to move on to the next slide, we can just sort of talk briefly about what you can do now if you still have questions or concerns about public charge. So then moving on to the next slide. First off, remember these key takeaways that we've really tried to emphasize, which is, that public charge doesn't have to do with eligibility for benefits. So people should still use the benefits that they need and qualify for. And then also public benefits received by family members don't count against the person who's subject to a public charge test. So if they're not the one receiving it, even if they, fill out the application, or like in the case of Daniel, I'm sure he had to have his parents provide their financial information when he was filling out his financial aid application, but they're not the recipient. And, with the example with Laura, right, as the head of household, she probably filled out the application to get benefits for her US citizen children. But again, she's not considered to be the person who's receiving it. And so that family member use doesn't count. And then as we've been talking about, right, public charge only comes up in 2 immigration situations: when someone is applying to come to the US or applies for a green card through a family or an employer. And then, finally, as we've been talking about, many immigrants aren't subject to public charge. I mean, of course, it's not an insubstantial amount of people who apply for green cards through family, but there's still lots of other immigration applications out there that don't involve public charge. And so we just want to remind people, it's not like every single immigrant is subject to a public charge test. And then I suppose with that, the last bullet point about DACA and TPS. So, right, those are 2 applications, immigration situations where we said there is not a public charge test when you apply for DACA or for TPS, but neither one of those forms of immigration relief is a direct pathway to a green card. And so someone in one of those 2 statuses or situations might later on find themselves on a path to a green card if they have a family member who can apply for them. And so when they sort of pivot to applying for a green card through a family member, then they would be subject to a public charge test. And then if we go on to the next slide. So what can community members do now? It's important to stay informed. On one of the last slides, we'll provide a link to some websites that have information on public charge. And then we also recommend getting an immigration consultation so that you can understand specifically how public charge affects you now and how it might or might not affect you and your future immigration options. And then it's also great to get involved. There are campaigns right now to advocate for more access to public benefits for immigrants, including those who are undocumented, and especially here in California, where we recently expanded Medi-Cal to those who are 50 and over, regardless of immigration status. And then on the next slide, just a reminder that when you seek immigration help or a consultation, make sure it's from a reliable source. Only attorneys or DOJ accredited representatives are authorized to give legal advice. Oftentimes there are, tax preparers and sort of other immigration consultants who might do immigration on the side, but they are not authorized to give legal advice. And so you should probably be wary if you get help from one of those individuals. And then some sort of hallmarks of someone who's a more reputable immigration service provider, legal service provider, would be they give you a contract, they give you receipts for your payments, they answer all your questions and make you feel heard and understood. And then they follow the rules. So if they tell you that they have an inside connection with the immigration agency or some other sort of special track, that's probably a sign that they're not reputable, and you should beware using their services. So on the next slide here, we have some links for places where you can find free or low-cost immigration legal services. That top one, you can also type in ilrc.me/find help for sort of a shorter URL that will take you to that same national legal directory. You can plug in your zip code and find either free or low-cost immigration legal services. And then the California Department of Social Services also has a list, which is that second link. And then lastly, there are free immigration legal services available for students, staff, and faculty on California community college campuses statewide. And then if we go on to the next slide. So just as a reminder, there are a lot of different immigration options out there, and many of these, almost all of these, don't involve a public charge test. And so, someone might not be eligible for a green card through a family member for some other reason, not having to do with public charge, but maybe one of these other options could be something that could be available to them. Okay, then next slide, we just have some suggested websites for other places you can get information. The top one is Aaron's and my organization, the Immigrant Legal Resource Center. We have a public charge webpage that has resources and information, and we try and keep it up to date as different changes occur. And then there's the Protecting Immigrant Families campaign, and then the National Immigration Law Center, or NILC. And then I think we're going to the next slide. That brings us to our time for questions.
Thank you for all that great information. So I know I see a lot of very case-specific questions, so we won't get into those. But for those individuals that submitted very case-specific questions, as Ariel mentioned, the Cal States have legal services available, as well as the community colleges. And the link to the Cal States and the community colleges free immigration legal services will be available in the follow-up email. But for now, if you're a community college student, you can also go to findyourally.com, enter your zip code and or college that you're attending, and be connected to a legal service provider with an available appointment. It usually takes about 2 minutes to schedule those consultations. So it's pretty easy and convenient, and you can ask all of the questions that you want and then some. So with that, we're going to go into some family member questions around a person that's receiving a green card through a family petition. Would the public charge be considered?
So in this, are you thinking like a family member is using a benefit, maybe like cash aid, and whether it impacts the family member, just to make sure?
I think the question is about, if they're receiving a family-based petition for a green card, does the public charge rule apply?
Right. Okay. So that like the idea of a family-based petition in immigration, some of you might be thinking of it by numbers. So we're thinking, I think, of what we call an I-130, or a family member petitions you, and then you're looking to get a green card. That is that traditional pathway where they do assess public charge. So that's when you would turn in an I-64 affidavit of support. And then they would look at that and the questions that you answered on your form and go, do we think this person's likely to become primarily dependent on cash aid or long-term institutionalized care in the future? And then based on that, usually with a strong emphasis on that affidavit of support, so long as that's sufficient, usually that's enough information to overcome any concerns about public charge.
Thank you for that further clarification. There's a question around if children accept the benefit for like cash aid assistance, do they have to repay those funds back? I know that might be a very case-specific question, and so
yeah. I mean, I think I can try to give a general, which is to say, there were a couple questions I think I can answer that I saw around the point that Ariel was making around eligibility for a benefit that's offered first by the state or a county or the federal government. They set their own eligibility criteria. So they set the criteria of who is eligible to use CalFresh or who is eligible to use Medi-Cal. And that is completely separate from public charge, right? So there's that first step. And this question is asking, well, I think if somebody qualifies for the benefit, so they go in, they say, hey, my name is this, I am a US citizen, or I am a DACA holder, and that agency says, you qualify for this benefit, then that's good news. So long as the person gave the right information and were honest in their answers, then they received that benefit legitimately, right? Mm-hmm. And generally speaking, for most benefits in California, if you were entitled to the benefit when you applied and you received it, there's no paying it back. So if you were like, at this point in my life, I have this income and this status, and it qualifies you for a benefit, you're not going to come back later and say, okay, now repay it. That's just not how it works. The one-time people are usually where we see repayment come up is when somebody fraudulently is using a service or benefit. And that means that they somewhere in the process told lies either about the income they had or about their status. And that's when repayment comes up. Ariel, I don't know if there was anything you wanted to add there.
No, I think that sounds good.
Thank you. And then sort of circling back on that financial aid question and the eligibility for public charge. And can you also touch if they become a legal permanent resident or a citizen, does the 5-year rule apply to accessing financial aid?
I don't know if you know, Erin, I don't think so, right? So all these questions that are sort of about like benefits eligibility is not our expertise because we do immigration law, and like we're trying to say, these are two separate analyses. So you all, actually, Alonzo, you might know more about financial aid eligibility than we do. But I don't know that there's any 5-year ban on accessing financial aid, right, Erin?
I mean, some of the financial aid, in fact, is limited to folks with, very specific statuses, and financial aid comes from various sources. And California has a unique structure also for some other financial aid. So I don't think that's anything that we could answer in a broad way.
Right.
And also definitely outside our expertise in terms of the criteria of various programs. But what we can say is it's not going to cause a public charge problem.
Perfect. Thank you. And I do see a lot of eligibility questions around like CalWorks and CalFresh and WIC. And so we did do a public benefits webinar that I will also link in my follow-up email to all of you because it is regarding more so eligibility rather than public charges, as Erin just mentioned. So I think we have reached the end of our sort of general public charge questions. Everything that I'm seeing is more so related to those that are trying to access and their eligibility. Just reminding
There's
everyone.
one thing.
Oh, go ahead.
Yeah, I mean, one theme that I did see in some of these questions, though, was this idea of people saying, like, I think, although we're saying we can't really answer every individual program's eligibility because that's specific to who administers that program, and it sounds like there's been a great webinar on that already, is that the questions are kind of mashing up that they think people are getting told not to apply because of public charge. In other words, eligibility and public charge get mashed together. And I think those questions are coming from somewhere. So I think people really are getting told this, right? Like, don't apply. It's not about eligibility. The person's eligible, but it's kind of getting mixed up into whether they are eligible or whether they shouldn't apply because of public charge. So I think step one is to just ask that clarifying question, like, oh, wait, is this about eligibility, or can you tell me if I'm eligible? And then separately ask somebody who knows immigration about, is it public charge? And I will say that there's been so much fear around public charge that people are saying, no, don't do it. You should be worried about public charge, when that's not actually the real information, or it's not the right answer. So just keep that safe list that Ariel went through nearby, like a lot of these programs where we said they don't impact public charge. And believe us when we say it, it's a list from the government, like WIC and CalFresh and all of these programs where people are hearing that maybe they shouldn't do it. And just know that that's not the case. It will not impact public charge. That fear does come from somewhere. It comes from a, rhetoric under a different administration and rules that are no longer in effect. So we don't have to worry about that right now.
Thank you. I think you said it just right. A lot of it has to do with a lot of misinformation and disinformation that's circling, and they are looking at eligibility and public charge as sort of one and the same. And so, again, please, if you have questions regarding, potential changes of status or family petitions, or if you're moving through the process and want to get a second opinion, or if you've been connecting with, your local notario or someone that isn't a licensed immigration attorney, I encourage you all to connect with our trusted legal service providers that we have both at the Cal States and at the community colleges, to check in with someone else. A second opinion never hurts, and all of our services are free and confidential. There is no information that gets shared with the state or the federal government. If you do decide to move into and apply, then that's when your information is shared, but you have already had those conversations with your designated attorney and what that would mean for you and your change of status. So again, all of our attorneys are free of charge, and go to findyourally.com for California community colleges, and the link for the Cal States will also be available to you all in the chat, as well as I'll include the public benefits webinar for all of you to continue to review, and hopefully we can answer some of those eligibility questions through that informational webinar. So I thank you, Ariel and Aaron, for your time today and your great wisdom and guidance around public charge. I will follow up with all of you through the email that you used to register for today's webinar with the recording, all of the links, as well as the PowerPoint presentation. So thank you, everybody. I hope you all have a wonderful rest of your day.
Thanks, everyone.